So, hi everyone. The unit we're doing today is Unit 7, which is Business Law. And my name is Shazia Khan. The learning outcome we're doing today is Learning Outcome 4, which was looking at recommending appropriate legal solutions to resolve areas of dispute. First, I just want to summarize what we did in the last session, which was to examine different types of business organizations. So, do you remember what we did in the last session in Learning Outcome 3? We looked at the different types of businesses we had. Sole trader, which other ones? Anyone remember?
Yeah, sole trader,
Partnerships?
proprietorship, and a company.
Partnership. Yeah, companies. What else did we look at in the last session? So you can just
Uh,
refresh.
the difference between unincorporated and incorporated,
Good.
uh, and company law in general,
Yeah.
and
Company's
how to
house,
hire,
yeah.
yeah, and how to hire director, secretary, and etc., and
Yeah.
how to register company.
Yeah, so we looked at shareholders, directors, their work. We looked at the history around evolving company law, how it evolved. We also looked at the different types of roles that shareholders, directors. We looked at the different types of companies, partnerships. We also identified the Companies Act that everyone needs to follow, and also the Companies House and the way a business is registered. So you've got an idea in your mind of how things are registered when it comes to setting up a company and what kind of company. Okay, so now we're going to look at appropriate legal issues to resolve areas of dispute. What do you think that means? Recommend appropriate legal solutions to resolve areas of dispute.
To solve different scenarios, like employee-employer disputes or company partners disputes or etc., like that.
So like dispute resolution, yeah?
Yeah, yeah.
So why is that important when we look at dispute resolution?
To form
Is
a
there,
structure to smoothly
yeah,
which allows smoothly to mitigate any long-term effects.
excellent. So for mitigation, before they go to court or anything, so they can
Yeah.
mitigate. So now the first indicative content is legal solutions for different types of dispute resolution. So we look at areas of employment, health and safety, equality of pay, claims, compromises, severance agreements, wrongful and unfair dismissal claims, corporate and commercial disputes such as breach of contract, contesting a damage claim, dispute between directors, and we look at commercial property, commercial lease transactions, real estate and investments. So the key terminology in the first one, legal solutions for different types of dispute resolutions. Disputes can arise in a wide range of contexts between individuals, which may be you and me, okay, civil disputes, and businesses, which are commercial disputes. Dispute resolution is the process of finding a resolution to an agreement, or sorry, to a disagreement between parties either outside or within the court system. Where possible, it is preferable and highly encouraged to find a solution to disputes without the need to go to courts. And this is often through the use of ADR, which is alternative dispute resolution. Sometimes as businesses, it's important to be familiar with dispute resolution methods to effectively handle any sort of conflicts that may occur within your business. So, you know, before anything goes to a court, there is the way of alternative dispute resolution. And the whole purpose of this is that is a way of resolving a conflict or dispute without going to court. Because, you know, when you go to court, is the cost of litigation quite high?
Yeah.
Yes. So they try to avoid the costs and they try to, you know, resolve this before they go to court, because if they lose the case, the court will more likely want them to make the court costs against them. So alternative dispute resolution is a much cheaper way than going to court, because it prevents you from, you know, trying to for you to pay the court costs. 5 types of resolution under the alternative dispute resolution. What do you think they are? Anyone? there's 5 alternative dispute methods that can be used. So we've got negotiation, mediation, arbitration, and adjudication. And these are the important methods that are used in trying to mediate something. So areas of employment, dispute resolution, health and safety is a big area. Why do you think health and safety is such a big area? We talk about health and safety, why is it a big area in employment tribunals or employment litigations?
Basically, it affects the life of the person, the employee.
And whose duty is it to protect the employee?
The employers.
Employer's duty. So health and
Yeah,
safety is an issue. Sorry, go on, Nandish.
No, nothing.
What's that? Sorry.
No, I've completed my sentence.
Okay, thank you, Nandish. So health and safety is an issue which affects all businesses, regardless of their size. In short, every business has a duty to protect the health and safety of its employees and members of general public who might be affected by the operations of a business. The steps which businesses have to take in order to discharge that duty can greatly depend upon the industry which within a particular business operates. So give me an example, Nandish and is it Ishika, sorry, about an example of where health and safety may go wrong, or an example of a situation.
In a construction site, in terms of physical harm.
Yes,
And
that's quite a big one,
of,
a construction site, isn't it?
Yes. And in
Yeah.
terms of office or consultancy work, it can be mental harassment or politics.
Yeah.
So that's that.
Yeah, health and safety in the construction field is quite a big one, because you need to make sure that they wear the right clothing. They need to know the law around it, what they can and can't do, and that's the same for any organization. Construction, there's probably a lot of cases of health and safety. Despite best efforts to ensure compliance with health and safety legislation, accidents can and do occur. When a serious accident occurs, it leads to an investigation by the health and safety inspector to establish whether the accident occurred due to the business's fault or to adhere to health and safety legislation. Where such failings are identified, the matter may lead to a criminal proceeding and or civil claims for damages in respect of any injuries that might have been sustained. And the criminal side would be that the company is not following the law, so they've breached the law. The Occupational Health and Safety Act 1985 includes mechanisms for the parties in a workplace to deal with health and safety issues that previously may have led to disputes. The mechanisms, consultation and negotiation between employee and employer representatives for the effective resolutions, issue of a provisional improvement notice by the health and safety representative, section 33, and seize work provisions when there is immediate threat to health and safety of any person, section 26, subsection 2. The Act encourages employers and employees to resolve health and safety issues in a spirit of cooperation. Ideally, every workplace should have an agreed procedure in place to deal with health and safety issues. Under section 26(1), employer and employee representatives must attempt to resolve health and safety issues through agreed or prescribed procedures. The issue resolution regulations prescribed a procedure for bringing the employers and employees together to attempt to resolve an issue where there's no agreed procedure. Now we've got areas of employment inequality of pays, and this is another area that's quite big in regards to disputes. The key, I think we've gone on the wrong slide. The concept of equal pay for equal work has a long history in the UK. It is over 50 years since sewing machinists at Ford Dagenham plant halted production, walked out and changed the lives of the working women. The machinists were informed their jobs were considered less skilled than men. That equality was reflected in pay, and women were receiving 15% less than the rate given to men, giving rise to equal pay disputes. So this has been a history around this for the last 50 years. It's nothing new. So, the equality of pay for women is different to men. Now the law protects women, but equal pay disputes continue. From actors to sportsmen to BBC presenters, equal pay disputes have dominated the news in recent times. Since April 2017, all UK companies with more than 250 employees are legally required to publish their gender pay gap data. Although it should be remembered that the gender pay gap and equal pay are different concepts. If you require advice on gender gap, please contact the experts on one of them. Equality pay. The key concept is one of the comparison between the claimant A and a comparator B. If A is a woman, then B must be a man. Under the Equality Act 2010, the terms of employment contract contains a sex equality clause as such as the purpose of equal pay claim is to improve A's term under the clause to the level of B's terms. A and B must be employed by the same employer and undertake work that is equal. There are three ways in which this work will be deemed equal. Work rated as equivalent. So this applies where a job evaluation study rates A and B's job as being equivalent. Like work, this applies where the work undertaken by A and B is the same or broadly similar nature. Work of equal value. This applies where the effort, skill, and demand required of people undertaking different jobs is determined to be equal. This is the determination only a tribunal or court can make after a detailed process of information gathering. So do you think equality in pay still exists today?
It is much better than it was in the 20th century, but there are still disputes.
Yeah,
And
exactly. You're right. It is getting better, but it's very slowly. And there are still cases that have gone to tribunals because of equal pay. Areas of employment tribunal, compromise and severance agreements. A severance agreement or redundancy agreement is another term for a compromise agreement. If you are at risk of redundancy or being made redundant, some employers offer a compromise agreement. This is a legally binding agreement where you and your employer agree the terms of your redundancy. What can the terms be of your redundancy? What kind of things can you agree? You are going to be made redundant. You can do a compromise or a severance agreement, and that would be like a legal binding document. But if you are to agree the terms with your your redundancy, what could that be? Could it be how much you should be paid? Could it be, when you should finish work? Your final day. So these are things that should be agreed with your employer. Importantly, you are giving away any claim you may have if you have been unfairly selected for redundancy or a proper procedure has not been followed. In return, you receive compensation. So what is the difference between a compromise agreement and a settlement one then? None is the short answer. They are both the same thing. Prior to 2013, settlement agreements were known as compromise agreements. They were to compromise claims that employees might have. In July 2013, the Enterprise and Regulatory Reform Act was introduced and the name changed from compromise agreement to settlement agreement on the basis that the language used more accurately reflected what the agreement was. They were a settlement of claims rather than a compromise of claims. Areas of employment dispute resolution, and this is quite a big area, wrongful and unfair dismissal claims. What do you think wrongful and unfair dismissal claims are? Give me an example of some where they may be
possibly on the basis of discrimination in terms of race or gender.
Yeah. Age, it could be anything. Disability.
Yeah. Disability,
It could
yes.
be the fact that you have a disability and you have a wheelchair and you go to work and you can't do certain jobs, so the employer says that you are fired on that basis. That could be unfair dismissal, couldn't it?
Yes.
Could you give me any other examples? when you look at religion, could you be unfairly dismissed on religion?
Yes, definitely. On the basis
Okay,
of
give me an
religion.
example of where you would be dismissed on religion.
Possibly it can be that uh, the practices that you follow, like the food
Yes.
case, can be an issue.
What about like if you need to pray?
Yeah, the pray, yes, pray as well.
Yeah, if someone discriminated you on that, that's quite a big thing to do because it's your right of religious belief.
Yeah.
So wrongful dismissal claims is a dismissal that is in breach of your employer's contract. The following types of breach of contract are often involved in wrongful claims. Breach of a notice, whether expressed or implied. An implied term is a term which, although not expressly set out in a contract, arises because it's intended by the parties to be included at the time the contract was entered into. Termination of a fixed term or specific task contract before it has expired, and breach of a contractual disciplinary or redundancy procedure. The most common wrongful dismissal claims that employees make is for breach of the notice period. Wrongful dismissal is a, oh, that's the next one. Sorry, I've done 2 slides the same. So what's the difference between unfair and wrongful dismissal? The following differences between wrongful and unfair dismissal should be noted. Wrongful dismissal gives rise to a common law action for breach of the contract that can be pursued in the civil courts or an employment tribunal, whereas unfair dismissal is statutory claim only which can be brought in employment in the tribunal. In a wrongful dismissal claim, a court or tribunal is concerned with whether a breach of contract occurred. In an unfair dismissal claim, the function of the tribunal is to consider the fairness of the dismissal. Unlike most unfair dismissal claims, there's qualifying period to bring a wrongful dismissal claim. An employee defending a wrongful dismissal claim can rely on facts that they found out after the dismissal, but in the unfair dismissal claim, a tribunal will be considered if the dismissal was fair on the basis of what the employer knew at the time of the dismissal. So what I'm going to do now is I'm just going to pause this and we're going to watch a video on alternative dispute resolutions and dismissals, okay? Yeah. Can you see
Yes.
the slides now? Yeah.
Yes.
So what did you think of that video on alternative dispute resolution? What did you think of the processes you've got to go through and you've got to go through negotiation, conciliation, arbitration, and do you think it's a fair process that you have to go through?
Yeah, definitely yes. But
What
as she pointed out, it is still intimidating process.
Yeah, but it's a process that they use before they go to court. Do you think,
Yeah,
there are
definitely.
advantages? Sorry?
Yeah, definitely.
Yeah. Do you think it's advantageous to use the process?
Yes, yes.
So the video identified what alternative dispute resolution and then looked at the process to go through mediation, negotiation, conciliation, different type of services as well. It's quite important to understand that. Now we're going to go on to corporate and commercial disputes. So a commercial dispute is a disagreement between 2 or more businesses regarding the supply of goods or services. These disputes may relate to quality, conformance, performance, delay, or pricing. There are a number of ways to resolve this dispute. So what kind of things, can you give me an example of a commercial or corporate dispute?
Possibly it can be between a fast food chain and a supplier for
Yeah,
particular vegetable or grocery.
yeah. Or a good hasn't been delivered, which is, not as, explain the quality of the good, maybe
Yeah,
the vegetables are not all fresh, like they've been described. So the quality
yes.
of a good is important as well. Maybe they've been charged a lot more than they should have. Breach of contract. Commercial contractual disputes occur when a disagreement between one or more parties takes place over a contract agreement. Common types of contract disputes are breach of contracts, service agreements, partnership disagreements, shareholder issues, and intellectual property. To limit your chances of breach of contract dispute, you must make sure the contract is clear and legally binding. Always consult a solicitor when writing, reading, or signing a contract. It's so important because you have signed a contract that, you know, the law, maybe it's in a breach of contract. You don't know what's in the contract. So why is it so important to identify this? Why do you think it's so important to identify that, identify that you need to read a contract properly?
Basically, so we can understand what is in the contract itself.
Yeah. What is in the contract? You are
Yeah.
signing something, so you need to know what is in the contract. How to resolve a breach of contract. There are two main ways contract disputes are resolved. Mediation, which is a process, which was in the video as well, she talked about it, which is a process to settle disputes in a diverse, extensive range of situations. The mediator is a facilitator, not a judge, and therefore does not take sides. So there's someone independent. So they just know what they've been given, the casework. So they don't know anything else, okay? So mediation is structured, interactive process whereby an individual, such as a solicitor or an advisor, who is impartial and neutral, helps the parties involved to reach a mutually satisfactory settlement. Why do you think it's so important to have someone who's impartial and neutral?
So it doesn't support one of the parties or is partial towards one
Yes.
of them.
Or is biased towards any of the parties? Yes, that's excellent.
Yes,
The
yes.
process is informal, flexible, voluntary, and confidential. Mediation involves limited costs and is very speedy with high success rates. The next way is litigation, and that is the process of taking a disagreement to the court of law, which again is more expensive and which again may not go in your favor because you may have to pay the court costs. Dispute between directors. So where possible, directors and shareholders should attempt to resolve their differences through dialogue or some form of alternative dispute resolution process in the first instance. If a resolution cannot be found, you should seek legal advice at an early stage to help you navigate your options. Causes of director disputes. Disputes commonly arise where lack of day-to-day involvement, commonly with smaller businesses. The shareholder directors will agree to actively work in the business. Over time, this may turn out not to be the case, and one may not be pulling his way or her way. Control, where one director looks to dominate the running of the company. Dividends and money, where one of the shareholder directors is taking an unfair amount of money out of the business. And breach of duties, one of the directors is in breach of his or her director duties, often due to conflict of interest or is otherwise actively damaging the business. So it's really important, that, directors are, taking everything quite seriously. Commercial property. Commercial property is a real estate that is used for business activities. Commercial property usually refers to a building that house businesses, but can also refer to land used to generate a profit as well as a large residential rental properties. Commercial lease transactions. A commercial lease is a form of legally binding contract made between a business tenant, your company, and a landlord. The leases gives you the right to use the property for business or commercial activity for a set period of time. In return for this, you will pay money to the landlord. Is commercial leases different to residential leases?
Yes, definitely the amount of electricity and water services and all the other services are different as well.
But why is it important to have a different lease for commercial and residential?
Their usage is different basically.
Sorry?
The amount they use different amount of resources.
So is it better to have a commercial lease for a big business?
Not for a big business, but if a country wants to promote business in its region, it can incentivize by giving some discount for commercial leases.
Yeah, and also, in a commercial lease, it outlines your rights and responsibilities of both the landlord and the tenant.
Yes.
So it's important, and it's important that any sort of provisions are dealt with. And in a commercial lease, it will cover following matters such as the type of property that's being let. What else will it have in it? Will it have the address of the property? It should have the length of the tenancy. Why is it important to have the length of tenancy in that property? How long you
Uh,
rent it for? So it identifies, whether you want the property tenancy for a fixed period or a renewable period. It also will include the rent charged and what kind of business you carrying at the property, who's responsible for it, and the security deposit. So it identifies all these jurisdictions. So, it's important that, the lease will also contain legal description of your premises. So this is things like, the fixtures, the leasehold improvements, the things like, fixtures and fittings. If there were any sort of damage to the property, who would fix that damage, and if you wanted to, what would you do if you wanted to terminate a commercial lease?
Possibly go through the same process of negotiation and that as well. But if you want to legally break it, you have to go through litigation.
Yes. And the only way for a commercial lease to be broken early is if the lease itself contains a break clause. So you might have to end the lease if you want to pass it on to someone else, or if you're allowed to sublet, or if the landlord gives you permission to end the lease. It's up to the landlord what he'll do if he allows you to end the lease early, because there may be a charge if you end the lease early. So it could either be for a fixed term or a renewable firm, and it could include like any sort of any sort of fixtures and fittings. So you might be accountable for that under a commercial lease. And it's the whole point of a commercial lease is you and the landlord coming up with an agreement, and the terms of that agreement again, and it's a document that outlines your rights and obligations for you as the tenant and him as the landlord. So you need to make sure that you are able to identify, what you expect from the landlord as well. You are able to renew it, and does the landlord have permission to refuse a renewal?
Yes, definitely.
Yes. He must, if he wishes to refuse or renew a commercial lease, and it must be on one of the grounds under section 30 and subsection 1 of the Landlord and Tenant Act 1954, and there must be reasons why he refuses to renew it. Okay. So real estate and investment properties. An investment property is a real estate property purchased with the intention of earning a return on the investment, either through rental income, the future resale of the property, or both. The property may be held by an individual investor or a group of investors or corporation. An investment property can be a long-term endeavor or a short-term investment. With the latter, investors will often engage in flipping, where real estate is bought, remodeled, or renovated and sold at a profit within a short time frame. The term investment property may also be used to describe other assets on investors' purchases for the sake of future appreciation, such as art, securities, land, or other collectibles. Why do you think it's, when we talk about real estate and investment properties, is there advantages and disadvantages of that?
Yes.
Can you tell me any?
Firstly, the price can vary in terms of your favor or not. It can definitely go up and down.
Do you think, when it comes to real estate, do you think it's mainly the whole point of real estate and investment is for a profit?
It can be for usage as well.
It's mainly, to do with, profit, really, to be honest, because, buying and selling and owning your own real estate, your own property, is there to provide you a benefit at the end of it. And
Yeah.
it's an investment strategy that can be both satisfying and lucrative, unlike, stocks and bond investment. And you could end up, getting a good investment out of it. And also there's risks of that, isn't there? So, if you want to invest in a property, there's also risks behind that. What kind of risks can there be behind that?
You can be sued for something possibly, and the major one is the price can go down or crash.
Yes, yeah.
Other
And
environmental factors,
yeah, it
like
could, yeah. And,
conflict.
sometimes
Yeah.
it's not always that you're going to make a profit out of a real estate or investment property. So, you need to be really careful when you want to invest in a property, that you research everything. Okay, so that's learning outcome 4 done now. And this is some of the references that we've used. Also, some of the information there is on the assignment, and an article there that you can read as well. A lot of the resources are available on Moodle as well. Have you got any questions around learning outcome 4?
Yeah.
Yeah.
One of the questions regarding Google, how was it able to fire like 12,000 plus employees in
Sorry, what's
January
that?
this year? How was Google able to fire 12,000 plus employees in prior this year in January, I think?
Yeah, I think the reasoning behind that was the issue with the situation in, were they all permanent workers?
I'm not sure, but
Yeah,
yes, I'm not sure
that's the
about
thing.
that.
Because they were not permanent workers, maybe that was the reasoning behind it.
But it included, I'm just reading it, I think so, it included both corporate staff and some
Yeah.
recruits as well.
Yeah,
Yeah.
it was, I think, was it around about 12,000 employees worldwide?
Yes. Yes,
Yes,
globally.
so it was a lot of employees. But the reasoning they said that they were when some employees were unable to access the system, they realized they lost their jobs. So, informed it was something that they'd done themselves. But I think some employees, if they've been unfairly, dismissed, they could challenge this. There's, I mean, they never give any reasoning behind that. They just, they just said that they had to lay them off.
Yeah, that is the reason why I'm asking.
Yeah,
Um,
and the thing is, if anyone wanted to challenge it, because it's such a big organization, it would be a lot of cost to go through, like court costs and things like that. So, why why would someone want to go through that? But I do know that, they have a tendency of historically, getting rid of employers. So it's a bit difficult to kind of contextualize, because the fact is that Google have been doing it for a long time, because historically I think they did get I think it was in the 90s where they got rid of 300 employees because they had a financial crisis. So maybe that's something they're going through now as well, but they don't want to declare it.
Okay, okay.
Yeah. Have you got any other questions, anyone? Ishika? Ishika, have you got any questions or anything? Have you got any other questions, Nandish?
No.
Okay, then what we'll do is thank you for attending the session today and thank you for your patience. And we've finished learning outcome 4, and the next learning outcome would be your assignment session, which is next week.
Okay.
Okay, so I'll see you next week for the assignment session. I think it's on is it on Saturday? Yes. So I'll see you next week, okay?
Okay. Have a nice
Thank you
weekend.
for attending today's session. Bye. Have a nice week.
Bye. Thank you.